Honorable Session. The Honorable Reese S. Hodge, Chief Justice. The Honorable Maria M. Cabret, Associate Justice. The Honorable I. Arlington Swan, Associate Justice, presiding. In the United States, Territory of the Virgin Islands, and this Honorable Court.
Good morning, everyone.
And good morning.
So we're gonna get the calendar for today, and we'll start with the first case, which is Burt versus Lockheed Martin Corp. et al. That's number 118 of 2022. Okay, Eric, you may proceed.
Good morning, Mr. Chief Justice, Your Honors. May it please the court, my name is Dana Horelick. I'm with Pullman and Comley. With me at council table is my associate, Megan Cauda. We represent the plaintiff, Mr. Burt. May I please
Could
reserve...
you just slow down a little bit so we can hear you and speak directly to them? Okay.
May I please reserve 6 minutes for rebuttal, Your Honor?
Very well.
Thank you. This matter comes before this court today following the improper granting of summary judgment in favor of the defendant on the ground that the plaintiff, Mr. Burt's complaint, was barred by the operative 2-year statute of limitations. The defendant's motion for summary judgment relied upon application of the two-pronged discovery rule from Joseph versus Hess Oil. The parties fundamentally disputed below the manner of its application and offered competing evidence furthering their respective claims. The discovery rule, as this court has applied it, is a doctrine of equity that tolls the 2-year statute of limitations until the victim knows or reasonably should know both his injury and its cause. Here, the largest dispute below was about what date Mr. Burt knew or should have known that he had contracted an asbestos-related disease and what caused it. Generally, the question of when a party knew or should have known something is an issue of fact that's left for the jury to decide. But the Superior Court decided to answer it instead. Weighing the parties' competing evidence and making all inferences in favor of the movement defendant rather than the non-movement plaintiff, the court concluded that Mr. Burt either knew or should have known that he had contracted an asbestos-related disease on March 18th, 2019, and that also as of that date, he was put on notice he needed to investigate the cause of his disease. Accordingly, the court held that Mr. Burt's complaint, filed on July 15th, 2021, was 3 months and 21 days late. If the court had drawn inferences in favor of my client as it was required to, it could not have granted summary judgment in favor of the defendant. Instead, the court resolved a genuine issue of material fact based upon improper factual inferences and findings and the improper interpretation of the discovery rule in contravention of this court's precedent. The judgment should be reversed and remanded. As a threshold matter, I'd like to begin very briefly with the defendant's claim for the first time on appeal to the challenge of the application of the discovery rule in the first instance. The irony to this belated claim is that the defendant's own motion for summary judgment relied upon the application of the discovery rule. And in fact, in the below proceedings, counsel for the defendants was asked specifically by the trial court whether they were in agreement that the discovery rule applied, and they said yes. This argument has been affirmatively waived. But even if it wasn't, the defendant is simply wrong. The two-pronged discovery rule has been repeatedly applied by this court. I'll look first at Santiago, which was decided in 2012. Chief Justice Hodge, writing for the majority, directly explored the two prongs of the discovery rule, and although it decided not to apply it to the facts of that case, acknowledged that there were two prongs. Justice Swan, in your concurrence to that decision, you expressly relied upon...
In which decision?
The Santiago decision from 2012.
Okay, yeah, Santiago versus housing.
Sorry?
Is it Santiago versus housing?
Yes, that's correct.
Yeah, okay.
Yes. In your concurrence, Justice Swan, you directly discussed both the first prong and the second prong and acknowledged that under the second prong, the victim, the plaintiff, must know not just that he or she is injured, but also the cause of that injury. Later in 2016, in United Corp versus Hamed, Justice Cabret, writing for a unanimous court, applied the discovery rule to allegations by a company regarding fraud of a former manager. The court, in that instance, applied the rule to find that a genuine issue of material fact existed as to whether and when the plaintiff should have discovered the fraudulent actions. Significantly, the court also in that decision acknowledged well-settled law that the question of whether a party knew or should have known something is typically a question that's reserved for the
Attorney,
fact
you know
finder.
something? I thought that this was a straightforward case of summary judgment, and the only issue is the statute of limitation. Am I correct?
That's correct, Your Honor.
Right, because that's what Judge Andrews ruled upon, and he granted summary judgment because he said that when the case was filed on July 15, 2021, the statute of limitation had already expired, even though there was tolling. And he said, as I understand it, he is saying that when Mr. Burt went to his attorney, and his attorney sent him for the medical examination, for the x-rays and whatnot, and when the doctor's report came back, the doctor's report made a nexus between his lung injuries and the asbestos, and they ruled out Hess, and they said no, when he was working at Martin Marietta. Now, it seems as if that the judge is saying that the statute of limitations start running from the time that the doctor informed, I believe it was Attorney Pate, who sent him to get the medical examination, and Attorney Pate is his lawyer, which would be his agent. Am I correct?
Correct, Your Honor.
Right,
That's what's
okay, so
happening.
notice to the agent is notice to the principal? Okay, good. So when the doctor informed Attorney Pate by way of a letter as to what they found from the medical examination, that the cause was asbestos, or I don't want to pronounce all those fancy medical terms. But all in all, I understand that the judge is saying, look, when that doctor sent that report and said this is the cause of it, and he would know that the only place that he was, because they had already ruled out Marietta Hess and Hess Oil, and they only were going with the aluminum company, that he said, this is what caused his injuries. Now, from the time that the doctor informed Attorney Pate, which is Mr. Burt's attorney, as to what was the cause of the injury, or the alleged cause of the injury, the judge below is saying that's when the time started running for tolling. And so because the notice to the attorney is notice to Mr. Burt, the client, and so that if in fact that the letter is dated a certain date, 2 years from that day, even if you allow for, let's say, mail-in and that sort of thing, that if the case was not filed, I believe, in March of 2021, then March 21st, 2021, then the statute of limitation has expired, even though there was tolling, because when the case was filed on July 15, 2021, the judge is saying, no, this is outside the statute of limitation. Well, if the statute of limitation decides when a case is supposed to be filed, there's no huge big issue of fact here, would it? In terms of why a jury, it would have to go to a jury. So why is summary judgment not applicable in this case?
I'd like to start very quickly, Your Honor, back up with your question where you described the letter from, or I should say the B-read impression, the lung scan impression, that Dr. John sent to Attorney Pate and that he received on March 18th. That impression, the B-read, does not reflect what the cause is. In fact,
is your argument that not only must there be a diagnosis, but also is your argument that who caused the injury must also be there before the statute tolls?
So I probably am going to give an answer that the court will not appreciate, but sometimes it depends. So in our argument here, first I want to back up. We're not arguing
well,
that.
I read the letter, I look at the letter, I look at the testimony, I look at the record, and I didn't have any hesitancy or compunction as to what the doctor was saying that was the cause of the injury. Okay? And not only that, but then the judge also is intimating that, well, since Burt knew that he works for possibly two companies, and they ruled out, him and his attorney ruled out Martin Marietta, no, not Martin Marietta, Hess Oil. They said, well, he wouldn't go in that group of people that was injured with Hess Oil, but he would fall into the group of Martin Marietta. So right then and there, along with the injury as elucidated and enumerated by the doctor, and Burt's own knowledge as to his employment record, as to who he was employed with, which seems to be that he also know who it is that where this injury was caused and why it was caused, and that should be enough to start the statute of limitation running. And so it's a 2-year statute of limitation. It hasn't changed yet unless somebody changed it last night. So that's what the judge is saying. I understand the judge is saying, look, this is a straightforward case. It's summary judgment. And we have the issue of agent principle. Since the attorney was informed as to the cause of the injury, and he both knew where he sustained this injury, which employer he was working with when he sustained this injury, then the judge is saying that I don't see any problem with having any issues of fact that would go to a jury in this case. So therefore, he granted a summary judgment. That is my understanding of your 10-volume, 6,000 pages of the transcript. I mean, of the record. It was interesting, had some good interesting stuff in there, and I kind of enjoy some of the things that I didn't know about in terms of scientifically. But when we come down to it and we remove all of the facade and we get to the essence of it, it's summary judgment, and whether or not, and summary judgment, the statute of limitation is straightforward. We don't need a jury to decide anything here when it comes to statute of limitation. There's no genuine issue as to any material fact once we lay out the time element. That's how I view this.
Your Honor, I understand my time has expired. May I respond to the question?
Let me just, well, I don't know. You want, go ahead and respond, and I want to ask you.
I'd also like to respond to Justice Cabret's question, but
yeah, go respond to Justice Cabret first, because she was actually in the middle of asking.
Justice Cabret, we're not saying that you need an actual diagnosis in order to understand the cause. What we are saying is that you need to understand where the injury came from and how it happened. And sometimes, in some cases, we can see, especially, for example, in the Santiago case, you know what the immediate cause is. So in that case, the plaintiff had been, she knew on a date certain, she'd invited a gentleman in to fix some plumbing. There was some toxic sewer solvent. The moment it was spilled in her home, she was injured. Her eyes were burning. She knew what the cause was. In other cases, for example, in Ray 22 Wells, the court has explained that, especially in cases involving environmental contamination, which admittedly this is not that, but very, very similar, the injury happens long before it manifests.
But
And when you're looking,
I understand that this is a creeping disease case where the symptoms are latent for a number of years, et cetera. But it's your argument that I'm really concerned about. Or that I want to understand more fully. You seem to be arguing, well, not only must there be a diagnosis, but the actor must be identified. Isn't that your argument in this case?
not necessarily. In some cases, yes. I think in this case, we did need to have some direction as to who caused it. And that sort of segues perfectly into Justice Swan's question, because this is not a cut and dry case. What we do have is disputed, a cut and dry case. So this
it's
is
not cut and dry?
no, it's not.
I think what you're arguing is that when you have the two defendants, an inference has to be drawn by the trial court that one of the defendants or both may have caused the injury.
That's correct.
But if you have just one of the defendants there, then the inference is drawn in whose favor?
Well, in this case, what's interesting is that all of the evidence that we introduced, the first communications between the plaintiff and Attorney Pate, only concerned the Hess refinery. Nobody found out that the plaintiff worked at least Mr. Attorney
But
Pate didn't
didn't
find
it
out.
also say that if it was not Hess, then he would have to be evaluated to see if he should be placed in the aluminum group?
The letter did not quite say that. The letter said we have identified you as having worked at Hess. If that's not accurate, please let us know so we can reclassify you.
No. I thought that his lawyer had indicated to him or informed him, at least that's what I gleaned from the record that I read, that his lawyer informed him that we are pretty sure that it was not caused at Hess.
That's
and
incorrect.
Therefore, the only other party would be the Martin Marietta group.
That's incorrect, Your Honor. In fact, that's one of the improper inferences that was taken by the Superior Court. When the court
It's
looked
either
at...
one or the other, though.
Yeah, no. Actually, that's not what the letter said. The letter simply said, you filled out an intake form. You only identified Hess. Where did you work? Hess. That's what it says. That letter was sent. It said, because of your intake application form, we've put you in the Hess group. If you worked at the Illumina group, let us know and we'll reclassify you. That's all it says. It doesn't say if you worked at the Illumina group, then you've been exposed to asbestos there. It doesn't say that, Your Honors. The defendants asked the trial court to make that inference, and it did. And that's one of the improper inferences that was taken. In fact, there is most certainly a dispute as to the meaning of this letter, as to the meaning or as to the substance of what Attorney Pate knew, and that's what needed to go back to a jury. That's what a jury needs to decide because the Superior Court is not allowed to make these types of inferences. What we know and the evidence that we produced at trial is that the very first time that Attorney Pate ever met with Milton Burt, the very first time they ever talked about the Illumina factory was on July 21st, 2019. Before
Well,
then...
hold on just 1 second, because you kind of, I find what you're saying kind of confusing. I understand that when Mr. Burt approached Attorney Pate and Attorney Pate, that they had the tryout in terms of the Hess group first. And then when the medical report came back, that they said, well, it wasn't necessarily at Hess, therefore we take you out of that group and put you in the Martin Marietta group, and you went back to the doctor, and then the doctor came up with this report. Now, unless the sequence or whatnot that I misread something, but that's my understanding as to, given the dialogue between Burt and his attorney, and what his attorney said, and as to the two groups, and as to where or what caused the injury, then, but I will look at all of that again because to me it was very clear that we are not talking Hess. As a matter of fact, Hess was not, was Hess sued?
Not in this case, Your Honor, no.
Okay. Was Hess sued at all in connection with Mr. Burt? No, all right. So then Hess was ruled out by both, by the attorney and at least by the medical report. So that we don't, it's not difficult to discern by way of elimination as to who would be the parties that we are talking about and who would be the parties that allegedly caused the injuries.
Only as of July 21st, 2019. I will very briefly run through the sequence of events, Your Honor, for
I
clarification.
think, I just want to ask you before you, well, you've gone over plus 8 minutes so far. Is it your argument that there can never, ever be summary judgment where the issue involves the discovery rule?
No. I think that perhaps and I don't think this court needs to decide this question. The question of whether and what the injury is, whether the plaintiff knew or should have known his injury and his cause is certainly a fact-specific question, but it certainly might be possible in some case that there's no dispute as to what the underlying facts are. For example, the Santiago case. I mean, it was clear that the plaintiff knew the time certain, the date certain, and what caused her injuries. I think...
But didn't Dr. John's report in March, didn't it say that he believed beyond a reasonable degree of medical certainty that he has evidence of underlying lung disease, and he says it was fibrosis, which is diagnostic of a history of asbestos exposure.
He
So doesn't that say, well, you know, what his injury is and the cause of it?
does not, Your Honor. What we know from
Well,
Dr.
he said to a medical, he used the exact language that the chief used, to a medical certainty after the examination, and I guess that after he went through whatever x-rays or whatever thing that they took of his lungs and so forth and so on, a doctor trained in these things said, to a medical certainty, this is my conclusion, and that was sent to the
So-
attorney.
Your Honors, I agree. That is the language that he used. However, what it means is up for dispute. It's directly disputed. What does that mean?
But what does diagnostic mean?
Well, according to Dr. John, who testified during his deposition, when he rendered the B-read impression, it was a blind read. He knew nothing about the
But
plaintiff.
he said
He'd
to a
never.
medical degree of certainty
Yes, Your Honor. He said
that
it was. Right. I'm sorry. I apologize.
fibrosis and it was diagnostic, I guess, caused by asbestos, and that it was caused by a history of asbestos exposure. So it's not saying what is caused and what it's caused by, and then wouldn't that put the plaintiff to a reasonable degree of some investigation to determine who caused it?
No, Your Honor.
If he didn't cause it, then it was caused by another. And that's all the rule requires, is that you know the cause and you know that it was caused by someone else.
In this case, Your Honor, Dr. John's B-read impression only showed what his medical expertise allowed him to see without knowing the plaintiff. It is entirely possible.
It only showed what?
It only showed what he's a doctor, so he looked at it and said, listen, a blind read, I know nothing, absolutely nothing about this person, I can tell you what this looks like. But it is entirely possible that theoretically the exact same B-read, the exact same B-read impression, the exact same instruction from Attorney Pate to go get the PFT, the pulmonary function test in July, could result in something completely different. Theoretically, what could have happened is he goes for the pulmonary function test, and let's say that it demonstrates an obstructive injury as opposed to a restrictive injury. Obstructive lung damage is caused by tobacco inhalation. Restrictive lung damage is caused by asbestos exposure.
All right, Attorney,
And
but,
so,
but here's my question. If in fact after he went to Dr. John, if there was some dissatisfaction, or if in fact Dr. John's report were not with specificity and clarity and succinctly, then why is it that he did not seek another? There's nowhere in the record I remember him seeking a second opinion. Am I correct?
he did not seek a second
He did not
opinion.
seek a second opinion. Well, if you go to a doctor like Dr. John, and he did diagnostic tests, and diagnostic means you're looking to find the cause of something. That's what I understand that you are doing. But if in fact that there is some hesitancy about reliance on Dr. John's report, well, you could always find another expert. Even if you have to go off island, go to Puerto Rico, or go someplace, even here in the Virgin Islands, so that to get at least within that 2-year span of Dr. John's report before the statute of limitation allegedly expires, why didn't he seek a second opinion from another doctor if in fact that there was some problem with Dr. John's report?
So, in full disclosure, the plaintiff didn't know he was injured. He testified at his deposition, which was filed months before the summary judgment motion was filed, or taken.
But he went to Dr. John because he was feeling sick, and he decided that, let me go talk to Attorney Pate. And Attorney Pate said, well, we have to find out first what kind of illness that you have, and that's why Dr. John came in.
Your Honor, no, that's not how it happened. The plaintiff contacted Attorney Pate because he spoke with friends from Hess who said, hey, if you sign up with Hess, you can get a lawyer and get some money. So he sent an intake form. He called Attorney Pate's office, got an intake form, sent it in that he worked at Hess. And Attorney Pate had never met him, had never spoken with him, and just said, hey, in order for us to find out whether or not you have any lung damage, go get this x-ray. So he went to go get an x-ray in St. Croix, and that x-ray report was sent to Louisiana, which is where Dr. John lives and practices medicine. And Dr. John did a blind read, a very quick look at that scan. So the plaintiff never met
What
Dr.
do you mean
John.
a blind read? He's reading the x-ray. Did he close his eyes when he read it?
Your Honor, I apologize for my verbiage. No, he did a read without knowing the plaintiff. So he simply looked at an x-ray, not knowing who it came from, where it came from, or the history of the person whose lungs it was. And so he performed that, and then he sent it electronically with his impression to Attorney Pate, who received it on March 18th.
So your argument is that's not enough. Dr. John's report is not enough. Are you saying that the pulmonary function test was required here and that was enough, the report that came after that?
It's the conversation that happened directly after the pulmonary function test. It was the first time.
Between Attorney Pates and Mr. Burt.
That's correct. That was the first time in this entire case that
Probably the entire work history.
Yes, and that's the first time the alumina refinery came up as tied to Mr. Burt. Nobody knew that he worked at the alumina factory except for Mr. Burt, who testified at his deposition. He'd never heard of asbestos. He didn't know what it was.
Not his knowledge, that's what's important.
His knowledge that he worked there is certainly important, but he had no underlying information to know that it was important. He didn't know what asbestos was. He didn't know there was asbestos exposure at the alumina refinery.
So at which point does due diligence kick in? I guess that's my real question.
So once you learn your injury, due diligence, you always have an obligation to conduct your due diligence in learning the cause. Whether or not you've done your due diligence is precisely the question of fact that should go to the jury.
Let me see if I understand you correctly, Attorney. You're saying that, well, we have some problem with Dr. John's report, but after Dr. John's report, there was some inkling as to this asbestos disease in the lungs and so forth and so on. If in fact that what I find very bedeviling to me is that there was no effort made by Mr. Burt or his attorney to get a second opinion. Wouldn't that show lack of due diligence? Because if you get a report like that from Dr. John, then that should raise a red flag that, well, let's see if there's something more to this to be absolutely certain as to the cause of this injury. And so let's get another expert. Let's fly you up to Atlanta, Miami, Puerto Rico, Virginia, or any place to get a second opinion to see whether or not it agree with what Dr. John is saying. But would not, in terms of using due diligence, in terms of notice, after Dr. John's report, there was a 2 years hiatus to get a second medical opinion that would either rebut what Dr. John is saying or at least support it, what he is saying as to the cause of this injury, and then you start the ball rolling. But certainly, 2 years is a pretty long time once you get a report from Dr. John in terms of not, if like I said, if you're dissatisfied with what Dr. John is saying, there is some hesitancy to use it, get another second opinion. Everybody gets a second opinion when it comes to medical illness.
Thank you. Your time is up, and we'll hear you on rebuttal. Thank you.
I would just say whether or not and what he should have done during that period of time is certainly a question of fact that a fact finder should have had. Perhaps someone might agree with you, Your Honor. Perhaps someone might not, but that is something that the jury should have discovered. And in fact, I would point the court to Attorney Pate's supplemental declaration, which demonstrates the process for these types of cases. Mr. Burt was one of 92 people who received the exact same letter that went out on February 7th. He was one of over 60 people that received a PFT between July 19th and July 21st in 2019. So he wasn't the only client presenting to Attorney Pate's office for these types of potential injuries and potential causes. He was
And that was
certainly
discussed below?
Yes, Your Honor, it was, and it was before the court.
Thank you.
If there are no further questions, I'd be happy to.
Thank you. Your time is up, and it's gone over 18 and 53 seconds.
Morning. May it please the court. Mr. Chief Justice, Justices, my name is Andrew Simpson, and along with my colleague Kevin Rames, I represent Lockheed Martin in this matter. I think, Justice Cabret, your question hit right on the head. Is it enough to know whether you apply the discovery rule or the statute as we think is proper? If you know the diagnosis and you know you have injury and you have a diagnosis of asbestosis, under either rule, that's enough to trigger the running of the statute of limitations. You then have 2 years to do your due diligence to find anything else you need.
Well, let's just start with your recent argument in your brief that I assume you didn't submit below concerning the interpretation of the statute and not use of the discovery rule. Why wasn't that waived, and why should we consider it now on appeal?
It's not waived because this court has made very clear, for instance, in N. Ray Callwood, that the parties cannot stipulate to the law below, and that on appeal, this court, most recently, in your opinion, Justice Swan, in the Fenton case last month, reiterated the rule.
Which
Fenton,
case?
the Fenton case of last month, it just came down,
Okay, all right, okay.
which goes all the way back to Antilles v. Lembach, which is that the court can affirm for the right result. If the court below got the right result, this court can affirm for any reason as long as it's supported in the record. And so as an advocate, it's our duty to make sure that we're arguing the correct law to the court, even if it was argued incorrectly below. So it's not an issue of waiver. If the case had gone the other way and we had not prevailed below, we might have an issue. But in a case where the court can affirm for any reason apparent on the record, you don't have the waiver issue at all.
Okay.
This is just another one of this court's right results, wrong reasons decisions. The court reviews the judgment, not the reasoning below, at least as the first instant. And
Well, but you basically stipulated below that the discovery rule applied, and now you're saying to us that it doesn't. We should just interpret the statute and not apply the discovery rule. So you're basically arguing two different things that the court below never had a chance to address.
I agree with you, Your Honor. The court below did not have a chance to consider the statutory argument, but we cannot waive it and not argue what we believe to be the correct law.
You can waive it, you can't stipulate to it, but you
But in any event, it doesn't matter, because under either, and as we said in the brief, it's just a different way of reaching the same result. The statute provides for the cause of action, the statute to begin running when the cause of action accrues, and when you have a latent injury like that, that's when you discover the injury. So that's the same time as if you apply the discovery rule. I don't think there's any functional difference. It's just a matter of how you perform the analysis, and whether you perform it under common law discovery rule or perform it under the statutory rule that the legislature adopted. But you get the same result. And that's why I was pointing out that the question, if you know the injury and you know the cause, asbestos, you have everything you need under either rule to trigger the running of the statute of limitations, and the 2 years to do your due diligence to identify a defendant if you haven't been able to do that previously. And as I point out in the brief, even if at the end of the 2 years of due diligence you haven't been able to identify the defendant, you can still file a case in the Superior Court under Rule 8-1, and name a John Doe defendant. So
that's another argument that you didn't raise below that you're raising now for the first time.
I think it's not an argument in support, or it's not an argument as far as the running of the statute of limitations. It's simply pointing out the opportunities that the plaintiff has to use that 2 years period to its advantage, and if necessary, it can even go beyond that. So it doesn't affect the underlying reasoning of the statute of limitations.
Yeah, no, but I read with much interest your rule on John Doe. And I'll tell you what could very well happen. And I hope that too many lawyers don't start with this John Doe business, because I immediately sense that if they start filing John Doe complaints, the only thing a John Doe complaint is going to do is just sit there in the court and going to back up the caseload for the judges. So I'm not saying that but I think that it has its drawback, So if somebody file a John Doe complaint, it presupposes that they will also continue to show due diligence and inform the court and still seek out this John Doe, which is supposed to be the culprit that caused the injury. Otherwise, to just file a John Doe just to stop the statute of limitation from running, and they don't do anything at all, and the complaint just sits there in the court's file for years and years and years. The John Doe complaint, as I understand, as you explained it in your filings, that that has a drawback for the court system, unless with the filing of the John Doe, it means that there will be a time limit when somebody ought to do something rather than just letting it sits there. In other words, don't file the John Doe alone, but show due diligence as to seek out who is the culprit that caused the injury so that a proper summons can be issued for that individual.
I can see the concern, Your Honor, but I think as a practical matter, we do not see a lot of John Doe cases, probably because 2 years to do your due diligence generally is enough.
Well,
so I don't think it's a problem in practice.
I have a secret. That secret is I don't think many lawyers are aware of the John Doe complaints.
Perhaps, but in any event, they
if
do
they
have...
won't ever get out of that. Boy, oh boy.
And that's certainly a matter of case management within the Superior Court. But the point is they do have 2 years. And remember, that's on top of, this has already been told for at least 25 years because of the lack of discovery of the injury.
That when you file a John Doe complaint, as I understand it, that it should stop the running of the statute of limitation. If in fact the rules allows for it, and if you file it within the 2 year statute of limitation, then it stops the running of the statute of limitation. So unless there's a strong incentive to find out who is this John Doe, what company or what individual, I could very well see, from my perspective and from the perspective of judges, that they can, our caseload and file cabinets can begin to mushroom if in fact that they don't use due diligence in seeking out and investigating the John Doe so that we can have a proper party substituted for the John Doe, and then the case can be moved forward. Because nothing much is going to be done under a John Doe complaint, because if you don't know who is this John Doe or who ought to be solved with process, it's not going to go anywhere.
I think that's certainly, if that were to become a problem, that could be addressed with the rules, but as I say, it has not been a rule.
Currently, the rule allows it, correct?
Pardon me, Your Honor?
Currently, the rule allows it.
Correct.
Okay. Why don't you address, why isn't there questions of fact, and why shouldn't this be allowed for the jury to decide exactly when he had that notice that's told that, stop the tolling?
One thing I definitely will address that, but I would like to point out that there was no argument in the opening brief as to specific facts that the judge found that were contested. But, so we have the February 28th, 2019 letter from the doctor. Now, this is after Mr.
That was a March one from the doctor.
Well, that's when the attorney received it. The letter is dated
Right.
February 28th,
Okay.
2019. Now, remember, at this point, Mr. Burt has, contrary to what was said by my colleague and her argument, he did know he was injured. He knew he was having trouble breathing, but rather than go to a doctor, he went to a lawyer. But his lawyer said, okay, let's send you to a doctor. Send him to the doctor. On February 28th, the x-ray is done, and it's diagnosis of pneumoconiosis, diagnostic of asbestos, and diagnostic of a history of asbestos exposure. Now, for starters, if that was the evidence at trial, if Dr. John testified just to that, and then someone else testified as to the identity of the supplier or the source of the asbestos, I would submit that would be sufficient to support a jury verdict. And if it's enough for that, then it's certainly enough to start the statute of limitations running. You do not need to know the identity of the person. So right here we have injury, diagnostic of asbestos. There's no question of fact. When did the attorney receive that? March 18th, 2019. That's when the statute of limitations started running because that's imputed to Mr. Burt. And Mr. Burt knows he worked at the aluminum plant. He has that knowledge. So even if you need to know a potential defendant, that knowledge being imputed to him gives him everything he needs to know. Now, for whatever reason, they don't have a meeting until July of 2019. And my colleague says, well, that's when they learned that it was the aluminum plant. But that's happening during the due diligence period. The due diligence period, the statute of limitations already started running March 18th, 2019. And unfortunately, a mistake was made. And lawsuit wasn't filed within 2 years of March 18th. But that's what it was. It was a mistake. There is no question of fact. It's that simple. Mr.
But
Burt.
it wasn't until, the July 21st meeting that Attorney Pate learned that he worked at the aluminum plant. And so doesn't that come into play somehow?
Not at all, because that knowledge doesn't need to be imputed to Mr. Burt. He already knows that. Mr. Burt knows where he worked. And I think it's also important to point out that first letter from Attorney Pate.
But knowing where you work is one thing, but knowing that there's asbestos and that's where he actually got the exposure, isn't there some question as to that?
No, there isn't. Mr. Burt answered.
And he said he didn't know that it was a bad thing,
Well, Mr. Burt knew that he worked with asbestos. He answered his interrogatories. He did not have the assistance of his attorney, according to his sworn interrogatory responses, in answering them. And he knew he'd been exposed to asbestos. He knew he had worked with insulation that had asbestos. Then his deposition is taken, and he testifies he knew the color of the insulation that had asbestos in it. He knew that he worked with it. He knew when he worked with it, because he knew that he worked with it with Martin Marietta, but he wasn't sure if he worked with it with Fialco. He had very specific knowledge of his exposure to asbestos. So there's no question of fact.
He said he didn't know that asbestos was a bad thing, and that, so even though knowing that he worked with asbestos, he didn't have knowledge that would expose him to the issues that he had in breathing.
But he knows he worked with asbestos. Then he gets the doctor's letter, or his attorney gets the doctor's letter that says it's diagnostic of asbestos, diagnostic of exposure to asbestos. So now the circle is closed. He's got everything he needs. So there is no question of fact.
No question.
No question of fact. The only question of fact.
The facts in the Joseph case were similar, correct?
Pardon me?
The facts in the Joseph case were similar. The court below granted summary judgment, and there was similar examination, and there was questions based on his deposition testimony. And the Third Circuit said, well, considering that he's not the most educated person, doesn't speak in the clearest of language, that there was a question of fact that should go to the jury.
I think there were other questions of fact in Joseph that aren't present here. But the facts of Joseph can't be imputed to this case.
I understand that, but I'm just trying to say that it was.
How is the Joseph case different from this case?
In the Joseph case, I don't think you have a situation where the doctor has opined as to asbestosis imputed to the attorney, and that knowledge at the time, in the time sequence we're talking about here. So I just don't see how they're.
But did you have a definitive diagnosis in Joseph? And when Joseph went to Dr. Sabedo?
I'm struggling to remember whether Dr. Sabato said it was, within a reasonable degree of medical certainty that it was asbestos, or whether it was, this is a possibility of asbestos, and I apologize, I just don't remember. But I think that's one of the key things.
You've answered my question.
Pardon me?
You have answered my question.
Good.
Yeah.
Thank you. I think that's one of the key things that, the council says, well, if we had the PFT test, that would have ruled out one thing or another. That might be the case if you had a situation where the Dr. John's letter was, this might be asbestos and asbestosis. Well, then maybe you need something further. But here you have Dr. John saying within a medical degree of certainty, this is asbestosis. So you don't need anything further to rule that in or out. I'm not sure if I was completely clear there.
How about the other elements, the silica, the dust? Was that clear from Dr. John's letter? Isn't that what more pointed towards the aluminum plant as opposed to Hess?
The presence of silica and dust?
Well, in the subsequent report from Dr. John, didn't he also mention those things?
Yes, he mentioned those other things, but that doesn't change what he mentioned at the time, that it was his opinion within a reasonable degree of medical certainty that Mr. Burt had asbestos that was diagnostic of asbestos exposure.
If it is determined that it's question of fact, why wouldn't it be simply, reversed and remanded for a jury trial, as opposed to your suggestion that it should be reversed and have a limited trial on the statute of limitations question first, bifurcated, and then why couldn't the jury do it all and answer the question on one verdict form?
Why take that away? I'm just picking back on Justice Hodges' question. Why take that discretion away from the trial court judge?
I think
Try the case.
I think a remand making that a possibility would be appropriate. I think a remand saying, you should consider this at least would be appropriate. I think you can also use your discretion to say this is how you should do it. The purpose of a statute of limitations is to cut off claims. And if the statute of limitations has run, the defendants don't get the benefit of it if it's combined with the trial on the merits. It's almost like, we're seeing the immunity issue coming up in national politics, but immunity is another one of these issues that should be decided early, and if necessary, you have a mini trial on it, rather than putting that off to the end when the defendant loses the benefit of a statutory right.
Thank you.
Thank you.
Eric, you got 6 minutes.
Your Honor. Start very briefly with the Joseph case. The defendant's interpretation of the rule from Joseph and its application to the facts here would effectively eliminate the requirement of the second prong. It's significant that in Joseph, the court specifically said you have to know the injury and the cause. The statute of limitations does not stop tolling to give you time to figure out the cause while it's running. That's not how it works. Under Joseph, you have to conduct due diligence, but you get that time before the statute of limitations stops tolling.
Why is it reasonable to wait 3 or 4 months before you even interview the client to determine that question?
Well, certainly the question of whether or not it's reasonable or unreasonable is one for the jury. It's not one that the Superior Court is allowed to make. It's a disputed fact, and the evidence in this matter here demonstrates very clearly that there's disputed evidence as to when Mr. Burt knew or should have known that his injury was caused by asbestos at the alumina plant. If we're looking specifically at the communications that he received from Attorney Pate, all of the defendant's arguments here are based upon inferences made in favor of the defendant in order to get from point A to point B and what they're arguing. That's precisely what the trial court did. In fact, if you look at the language of the Superior Court's decision itself, it says things like, the court is not swayed by this argument. It says the court rejects this argument. I mean, the court is making credibility determinations that it's not allowed to when it comes to the disputed evidence. These questions should go to a jury. Brother counsel mentioned that if this had gone to a jury and certain evidence was put on, we would love for that to happen. That's what should happen. That's what should happen here. These questions should be remanded to go before a jury.
Which jury, because he kind of suggested it should be bifurcated. Do you in favor of that, or you prefer just have one trial and let the jurors decide both issues? Number one, the statute of limitation issue, and number two, the case on the merits, the claims on the merits. Because if it's not bifurcated and it goes to trial, and if they say that there was a statute of limitation, that's it, they would just come back within a certain period of time and just say so, and then that would end the whole thing. But the bifurcation would save a lot of time, a lot of money, a lot of expense, if you bifurcate it only on the narrow issue of the statute of limitation, whether they go to a jury or not. Because I tell you, if you're going to have the two issues, the merits of the claim and the statute of limitation issue, to go on the merits of the claim, I could see just an avalanche of medical testimony, medical doctors, medical experts, and everybody coming in there. We're talking about days of trial. That's a tremendous amount of cost.
It is, Your Honor, but I would pivot back to Justice Cabret's question of Brother Counsel. Why should the trial court be divested of the discretion to make that decision? It shouldn't. The question of bifurcation is one that is within the trial court's broad discretion to decide. And quite frankly, the application of the statute of limitations and when it stops tolling, not which statute of limitations applies, that's a legal question, but the question of when it stops tolling and when it starts running is a factual question. It's always reserved for the jury. That's why it's put forth as an affirmative defense by the defendant. So there's no need for bifurcation here, but the defendant is free to make that claim once the matter is remanded to the Superior Court for further proceedings. I would add, Your Honor, with regard to the timing here, Brother Counsel references the ROG responses, the interrogatory responses that the plaintiff submitted. Those were submitted well after this lawsuit was filed. And it's clear that he knew by the time the interrogatory responses were filed that asbestos is a bad thing. But we produced very clear evidence that he said at the time he worked, or at the time he even went to see Attorney Pate, and he went for the x-ray, he had no idea that the materials that he worked with were asbestos. Never mind, he also didn't know that asbestos was a bad thing, but he didn't know he was working with asbestos.
But then he also said he spoke with other co-workers at Hess who was suffering similar to him, and they told him that asbestos caused it, and that they had gone to Attorney Pate and had gotten money, and he should do the same.
So his communications with prior colleagues, at least according to his declaration, were much shorter and less information. It was, hey, if you worked at Hess, go see this lawyer because you'll get some money. I mean, it was there was no discussion of disease, there was no discussion of symptoms. When he filled out the intake form, he indicated only Hess, and he declared he averred in his affidavit that it's because he thought if he said he worked at Hess, then he'd get some money.
He said he was sick also, just like them.
Actually, when he was referred to the x-ray, when he went and submitted the form, he didn't know if he was sick. It wasn't until, and we would concede, and I hate making concessions as an appellate lawyer, but I need to, on March 18th, he knew of his injury. That's the date that Attorney Pate received the B-read impression from Dr. John that said, you have lung damage. Now, this goes back to...
You're conceding that agent relationship and that notice to the attorney is notice to him.
Yeah, there's no, yes, Your Honor, but what I don't concede.
You didn't seem to concede it, so I just want to know.
I know, like I said, concessions make me nervous. But here I think it's important to note, listen,
so at least that part of the judge's memorandum opinion, you are conceding that is correct.
Yeah, we do not dispute the fact that he knew of his injury as of March 18th, 2019. Let me be clear about what I'm not conceding. we do not concede that he knew or should have known the cause of that injury as of March 18th. And in fact, it's our position, and we believe it's demonstrated by the evidence, that the credible evidence we put before the trial court, that he did not learn that until
You're
July.
saying when Attorney Pate got that report or that letter, as you call it, the impression from the doctor that it was asbestosis and it was caused by exposure, long exposure to asbestos, that to Attorney Pate would not notify him, one, that it is asbestosis and that it was caused by long exposure to asbestos, and that would not have put him on notice that, look, this is the injury, this is the cause, let's just go out and find out, who was the other person that caused it, because all you need is that you were injured and it was caused by a third person, and you don't have to find out that is all that needs to be put you on notice, that you should then investigate and determine who caused it.
Well, that's not what Joseph requires, but in any case, looking at the facts here, on March 18th, the impression said that the lung scarring, the lung damage, was diagnostic of someone with asbestos exposure, diagnostic of someone with asbestosis and pneumoconiosis. I have problems with the medical terms too, Justice Swan, so you're not alone. But what we know is that Dr. John later testified at his deposition that that's not a diagnosis. He wasn't saying the cause, and in fact, he never makes a diagnosis and never ties a cause. He himself is a practicing doctor until he has the opportunity to speak with the patient and find out their work history. That full picture is what gives you a diagnosis. Now, we're not saying that he needed to wait until he received that diagnosis, but what we are saying is that there was most certainly disputed evidence before the Superior Court that as of March 18th, what Dr. John put in that report was not showing what the cause was. It's up for debate. And the trial court took that question that should have gone before the jury and decided it for itself. And in doing so, it made the inferences that the defendant asked it to make, which it is not allowed to make. Inferences must be made in favor of the non-movement. That would have been the plaintiff, and we certainly put forth evidence against the defendant's arguments, and the court should not have nevertheless made inferences in favor of the defendant.
Let me see if I understand you correctly. You are saying that the court precipitously or prematurely ruled on the statute of limitation. Is that what you're saying?
Sorry, can you repeat the question, Your Honor?
Are you saying that the judge prematurely or precipitously ruled on the statute of limitation?
Yes.
How long should the judge have waited if he didn't rule at that time, well after the statute of limitation had expired?
The judge should have deferred the question for trial to be heard, and this brings us back to the very first question we started with in my rebuttal. The judge, that's a question, it's an affirmative defense, that there's a question of fact for the jury to resolve, and that should have been left for the jury. So it should not have been decided on summary judgment. Where there's a genuine issue of material fact, the case law we all learned in law school, that the issue needs to be reserved for the jury.
All right. Suppose in all this 6,000 plus pages, the same thing that the court had is what the jury's going to have. You think that the decision would be any different from what the court ruled?
Yes. Well, we feel very strongly that our evidence demonstrates that both attorneys. Even
though, given the notice again, that 2 year statute, that period of time, when that letter came back from the doctor, the diagnostic tests and all of that he said, I get the distinct impression that no effort was made to get a second opinion or to find out what exactly it is all about. So the statute of limitation is running at that time. How long, what else was there that the jurors would have heard other than what's already in the record before us?
Well, Your Honor, with all due respect, I would question the premise of your question. Joseph requires both knowledge of the cause, the injury, and the cause. The standard that the defendant is advocating for here is an inquiry notice standard, which says once you know the injury, the statute of limitations starts running and you are charged with doing your due diligence and investigating the cause
Good.
during the
I'm
pendency.
glad that you said it, because I think we're going on a circuitous route, you
Yes.
and I. Because it seems to me that given what was said by the doctor to Attorney Pate, and knowing what Mr. Burt knows in terms of his employment history, when were they gonna get around to having anything more, let's say, a more medical opinion other than what was already before the court?
The reasonable steps that should have been taken is a question that should have been left for a jury. What I will say is that the court in Joseph dealt with this issue, and it said that the court has specifically rejected the argument that any individual who has been exposed to asbestos in the workplace should know that he has an asbestos-related disease as of the date he learns health hazards posed by asbestos exposure.
Yeah, but you see, but we have two
That,
things
that,
here.
what that says is
Yeah.
as of the date he was exposed.
Yeah. And we
As
have,
of the date he was exposed.
As of the date that he learned of the hazards to asbestos exposure.
As of the date that he what?
It says, as of the date he learns of the health hazards posed by asbestos exposure. So in other words, an individual shouldn't be charged with having known when the injury occurred that it's bad because he learns later that it's bad. So the fact that he worked there isn't enough.
I will tell you what is the problem that I have. I have this problem. This gentleman worked for years at Martin Marietta. His health began to deteriorate, and along a kind of a precipitous route. He spoke with other people, other workers similarly situated. He even mentioned that one of them might have died, and he's feeling sick. It has to do with the lungs. He goes to his lawyer, and his lawyer said, we need to find out what is it that caused you to feel sick. So he sent him to a doctor. A doctor did a diagnostic test, and the doctor, whether he looked at it in a cursory fashion or whatever, the report is there, and the report says, in essence, that there seems to be a nexus between where you were working with asbestos and your lungs and your lung injury that you now are suffering from. He told a letter sent to the lawyer, and you would agree that the lawyer is the agent for the plaintiff, and therefore knowledge to the lawyer is knowledge to the plaintiff. Along with the knowledge that plaintiff has of his own employment history, and now that he have this other thing that seems to say that, asbestos seems to be the issue, why would it couldn't get this case filed within the 2-year statute of limitation? Even after tolling, because they got some extra time now.
So, Your Honor, the reason for waiting nearly the entire statute period is not in the record. Theoretically speaking, in these cases, the plaintiffs are one of many. There are many related cases, and oftentimes there are settlement discussions and other efforts made by both sides that try to avoid the litigation in the first place, and that often takes a majority of that time. So
You said there were efforts made by both sides to settle this matter?
that's not in the record, Your Honor. I'm just speaking theoretically.
No, I'm just saying that because, settlement talks should not really deter. Lawyers got to be very careful about settlement talks because, when I had cases, I would always go ahead and make sure that my complaint is filed within the statute of limitation and the case is continuing, because that has a way of expediting settlement talks or settlement conferences. But anyway, that's beside the point. The thing that I have is that what is there that after you got a report that we got from Dr. John of his illness, and he himself knows his work history and what he was exposed to, and he's now told all of that, and apparently no second opinion was asked for. Why could this not have been filed within the 2 years?
So Dr. John, when he issued that decision, did not know his work history. There is a genuine issue of disputed fact as to what someone should have known from
I'm not talking about that. I'm talking about the due diligence. And what I'm talking about, the due diligence, is that, wouldn't Dr. whether you want to rely on the doctor's report or not, would not raise a red flag as to the causation in terms of the injury, and that if you think that you need a second opinion or you need further study done, that could not have been done within 2 years in order to satisfy the statute of limitation that expired on March 15th or 2021, or March 19th or something.
The short answer to your question, Your Honor, is maybe it could have been found, maybe it couldn't have. The point is that that's a question of fact that should have been sent to the jury, whether or not the statute should have started running on March 18th or whether it should have started running on July 21st.
Well, how much notice does somebody need, for heaven's sake?
But you need more than notice, Your Honor. Under Joseph, you need more than that.
But he knows who the party is. Mr. Simpson was talking about the John Doe complaint. Well, we don't have a need for no John Doe in this case. We already knows where he get his injury from, and
He did not learn about the aluminum plant until July 21st, 2019. And we put forth clear evidence reflecting that.
March when?
July 21st, 2019. That's the first time that Attorney Page...
And when did his lawyer learn about it?
July 21st, 2019. Until then, all discussion had focused on Hess. The alumina plant had not come into the discussion at all.
Okay, thank you.
If I may briefly conclude, Your Honor.
Well.
Thank you. We'd ask that the judgment be reversed in its entirety. I would be remiss if I didn't mention that if the court is inclined not to reverse in its entirety, the issue of the bauxite claims and the alumina, the dusts, wasn't raised at all, and there's no question in this case that a summary judgment was improperly granted as to those claims in the complaint. So we'd at least ask that those be reversed, but it's our firm position that the entire judgment should be reversed and remanded. Thank you.
Thank you. Is that a last-minute claim?
Sorry?
Is that a last-minute suggestion?
It's in both of our briefs, Your Honor, but...
For the bauxite? And,
yes.
And that the court should not have dismissed the entire thing?
Correct.
Okay, thank you. Okay, the matter will be submitted. Thank you both.